Hi, my name is Gina Desmond, and I'm an advocate with Disability Rights of West Virginia. And today we are here to talk about housing, rights, and responsibilities. So I am an advocate, I am not an attorney. The material presented here is intended for informational purposes only. It is not meant to be legal advice. So who are Disability Rights of West Virginia? Congress mandated that each state have a protection and advocacy system to protect the rights and interests of persons with disabilities. So Disability Rights of West Virginia, we are West Virginia's federally mandated protection and advocacy system. We are a private, nonprofit agency, and our services are confidential and free of charge. Disability Rights of West Virginia helps people with disabilities by giving information and providing referrals, investigating abuse and neglect. We provide direct advocacy, provide training on self-advocacy and rights. We support self-advocates. We provide legal representation, and we engage in systemic advocacy and litigation. There are several things that we are unable to do. We cannot provide representation for family or criminal law. However, our staff attorneys can provide technical assistance to attorneys regarding disability rights. We cannot provide representation for bankruptcy, probate of an estate, personal injury, eligibility for Social Security benefits, establishing guardianships. However, we can assist with revoking a guardianship if it is inappropriate. If the person, maybe they were in an accident, they got a guardian and now they have healed and no longer need a guardian, or there are abuse or neglect issues with the guardian. We also cannot provide assistance on non-disability related issues. So we have 9 federal grants and 1 state grant. 4 of those grants are disability driven. We have our PAD program for individuals with developmental disabilities, our PAMI program for individuals with mental illness. Our PATB program is for individuals with a traumatic brain injury. And our PAIR program, that is for individuals that have an impairment of a major life activity, including self-care, seeing, hearing, eating, walking, speaking, breathing, learning, reading, concentrating, thinking, communicating, and working. So you can't fall into one of the other disability criteria. However, you still have that impairment that limits a major life activity. So some examples would be somebody that has a diagnosed seizure disorder or is blind or deaf, has a spinal cord injury that maybe limits their ability to walk. We also have 5 issue-driven programs. So the first one is our PAT program, and that is to help people access assistive technology devices or services, including durable medical equipment. Our CAP program, this helps people who want to receive services from the Division of Rehabilitation Services or a Center for Independent Living. We can also give information about Title I, which is the employment title of the ADA. Our PAVS program is for individuals who receive SSI or SSDI benefits who desire to work. They want to work, but there is a barrier preventing them from working. Sometimes we just give information because people, they didn't realize that they could work while receiving these benefits. Our PAVA program, this is our voting access grant. It provides access and advocacy related to voter rights, including accessing the polling place and registering to vote. And then the last federal grant is our representative payee program. And with this, we can monitor and investigate how Social Security representative payees are administering the Social Security funds for the clients. We also have 1 state grant, the Medley-Hartley Advocacy Program. Medley was established due to a class action lawsuit and the Medley consent decree. It mandated that people with developmental disabilities be served in the least restrictive environment and receive individualized services based on assessments. This was what really began the closing of the institutions in West Virginia, the developmental disabilities institutions in West Virginia. Currently, there are just over 300 active Medley class members. Again, they receive lifetime advocacy. And we are still finding people eligible to be a Medley class member. In order to be eligible, you have to have a diagnosis of an intellectual disability, be born on or after April 1st, 1956, and then been institutionalized before your 23rd birthday for 30 or more days at one of the DD institutions. So that would be Sharp, the old Weston Hospital, Bateman, the old Huntington State Hospital, Lakin, Colin Anderson, Greenbrier Center, Spencer, or Hoagmont. Currently, there are 2 institutions. So if you are 23, but before your 23rd birthday, if you have an intellectual disability and you are hospitalized at Sharp or Bateman for more than 30 days, then you can become a Medley class member and have access to a lifetime advocate. The Hartley program was established due to a class action lawsuit. It was the catalyst that changed the state's behavioral health system. It established the behavioral comprehensive centers. It added additional services and supports for people with disabilities. Through this grant, there's a very narrow focus for the people that we serve on this grant. So with all of our grants, our federal grants and our state grants, we work in the following systems: special education, the home and community-based waivers, so the IDD waiver program, the traumatic brain injury, the aged and disabled waiver. We go into state and private psychiatric hospitals, investigate death or serious injury, abuse and neglect. We provide advocacy related to financial exploitation. We also work in jail and prison, medical or mental health care, housing rights, and accessibility issues. We also monitor DHHR facilities, juvenile facilities, correctional facilities, nursing homes, group homes for people with developmental disabilities, non-state psychiatric facilities, specialized family care homes, and assisted living facilities. So advocates and attorneys will go into these facilities, talk with administration, talk with clients. Okay, so the basic rights about fair housing, federal and state. Under the Federal Fair Housing Act, a landlord cannot discriminate against an applicant because of the applicant's race, color, religion, sex, disability, familial status, so the presence of children 18 years old or younger, pregnant women, or persons anticipating adoption, or national origin. So those are the Federal Fair Housing Act. Under West Virginia's Fair Housing Act, a landlord cannot discriminate against an applicant because of everything that the Federal Fair Housing Act covers, and the state of West Virginia's Fair Housing Act added blindness and ancestry. The goals of the Fair Housing Act are to provide protection against discrimination, protect applicants so that all qualified applicants are invited to equally apply for rental housing, and to ensure that all qualified applicants are screened. So what type of housing is protected under the Federal and State Fair Housing Act? So private housing, housing that receives federal financial assistance, state and local housing with some exceptions. All types of housing, including public housing, are covered by the Fair Housing Act, except rental dwellings of 4 or less units, where 1 unit is occupied by the owner. Single family homes sold or rented by the owner without the use of a broker. And then housing that is owned by private clubs or religious organizations, as long as they restrict occupancy or tenants in the housing units to their members. So what are landlords' rights and responsibilities? So the landlords, they have the following rights: to collect rent in according to the terms in the lease, to evict a tenant or terminate a lease if the tenant fails to pay rent or uphold provisions of the lease agreement. Here are some landlord responsibilities, and this is not a complete list, but to provide general maintenance to the rental property, keeping the property fit and habitable in compliance with all health, fire, safety, housing codes, and to make all repairs necessary to keep the premise fit and habitable. Unless the need for repairs were created by lack of care of a tenant or a member of their family, somebody that is on the property with permission. They're also responsible for keeping the home in good and safe working order with electrical, plumbing, heating, ventilating, sanitary, air conditioning, other facilities and appliances. So like elevators, if they provide washer dryers as part of the lease, anything else that the lease requires. So, and it is important to note here that a tenant cannot waive their rights to live in habitable housing. So if the landlord needs to come in to fix a leaky sink, the tenant has to let them in to fix it. Now they can make arrangements so that it is when it's a good time for the tenant, but again, the tenant needs to let the landlord or the maintenance department in to provide this service, to make sure that the home is in safe and good working order. So along with landlords' rights and responsibilities, tenants also have rights and responsibilities. Again, this is not a complete list. So the tenant has a right to rent a premise regardless of their race, religion, color, national origin, ancestry, sex, blindness, disability, or familial status. And again, they have the right to live in a premise that is fit and habitable during the duration of their tenancy. So when I do these this training live, I like to give some polls just to get people thinking. So I will go ahead and ask these just to get you guys thinking. So the first poll is true or false. A landlord must renew a lease. So once your lease expires, that landlord must renew it if you still want to live there. Go ahead and think about that for a second. Okay, so again, tenants, their rights and responsibilities, they have the right to complain to landlords or local government agencies. So this can be building code inspectors, fire marshals, health departments, if the landlord fails to maintain the property. And the landlord cannot legally evict the tenant because of complaints made, okay, about the unfit housing. But the landlord has no legal duty, so they are not required to renew a lease once it naturally expires. The tenant's responsibilities include, but are not limited to, paying the rent on time and in accordance with the terms on the lease. To pay for all damages caused on the property by the tenant or someone that they let onto their property, into their home. So friends, family members, guests. And then to behave or make their guests behave in a way that doesn't disturb of others' peaceful enjoyment of their property and does not cause undue wear and tear on the rental property. So some examples of housing cases that we have worked. We got a call from a client, this was at the very beginning of COVID, who was preparing to evict one of our clients. The landlord said that the client didn't pay the rent. The client said they got a money order and that they mailed the money order. There was no history of the client not paying the rent pre-COVID. She always went in and paid it in person and it was on time. So there were no issues. So I advocated for the client to mail the rent certified, so that way the landlord could track could track the mail, ensure that the client purchased the money order and got it in the mail within the terms outlined in the lease. And the client is still living there, so that resolved the issues until the client felt comfortable enough. Again, I believe she pays in person again now. Okay. An example of a case that we were not able to take, there was a person with a disability and they lived in a HUD subsidized apartment, and the landlord was evicting them because the person's son and his friends were frequently in the apartment and were arrested for selling drugs. It was more than just a one-time offense. There were multiple warnings and multiple police calls and several arrests, actually. And so we were unable to assist because the eviction was not due to disability related issues. However, we did give information about other advocacy and legal services that may have been able to help her. So even if we can't help, we do try to provide information on agencies that could possibly provide those services. A landlord is not responsible for making repairs to the property that were caused by the tenant or others, again, guests that were there with permission of the tenant. So if somebody punches a hole in the wall, for example, a landlord is not responsible for making that repair. And again, a tenant is responsible for the action of their guests. So another poll to think about, true or false? Landlords have insurance to cover personal property damage. So landlords have insurance to cover personal property damage. Think about that for a second. I'll tell another story. Another case example of something that I worked many years ago. There was a gentleman who was diagnosed with a mental illness who was having some side effects of his medication. He ended up causing a disturbance in the public area of the apartment building, and he accidentally caught his lunch on fire in the microwave and then went to put it out in his bathtub, which caused damage to the bathtub. And the landlord gave an eviction order. We received a call. I don't remember if it was from the family or from the behavioral health comp provider, but we received a call. We worked with the person's sister and their behavioral health comp provider. And what we found was that the client was in active treatment, okay? And he went to his prescribed doctor's appointments, took medicine as ordered by the doctor. And what had happened was one of the medication levels were off, just naturally, no fault of his own. Again, they participated in groups. And once this happened, they sought treatment, hospitalization in order to become stabilized. So we got written letters from the comp center saying that, again, he was following all of the medically care. He was following his doctor's orders, and we were able to advocate for, again, the client not to be evicted. And his family agreed to make payments on the damage to the bathtub. So still had to pay for the damage to the bathtub. But again, we were able to get him to stay, and because he had lived there like 10 years and there were never any issues, and payment arrangements were made. So this was a good outcome. Okay, so the true or false, it is false. Landlords do not have to have insurance to cover personal property damage. Okay, so the tenant is responsible for their personal property if it's damaged. Again, landlords do not insure anything other than the building, infrastructure, elevators, air conditioning systems, etc. If a tenant were to accidentally start a fire, for example, and damaged your property, the damage would not be covered by the landlord's insurance. So it is recommended that tenants obtain rental insurance to protect their property in case it is damaged. Accommodations and modifications. Under the Federal Fair Housing Act, it is required that accommodations for persons with disabilities be made if the accommodation is reasonable and necessary to afford persons with disabilities equal opportunity to use and enjoy housing. So another poll, true or false? In most cases, a tenant is responsible for paying for reasonable modifications. So in most cases, the tenant is responsible for paying for reasonable modifications. Under the Fair Housing Act, owners of the facilities are required to make reasonable accommodations in their policies and operations that allow people with disabilities equal housing opportunities. And then they are required to allow tenants with disabilities to make reasonable access related modifications in their private living space. In most cases, a landlord is not required to pay for the changes in private living spaces. So again, in most cases, the tenant is responsible. So some examples of reasonable accommodations can be adjusting the date that a rent is due to correlate with Social Security checks or paychecks. You can assign a lower mailbox. Let's say you live on the 10th floor, so that means that your mailbox is higher. If you can't reach the 10th floor, then they can reassign a lower mailbox, or designating a parking space. So those are some accommodations. The landlord may be responsible for making changes to private living spaces and common use areas such as mail and laundry facilities under the Fair Housing Act if it was constructed after March 13th, 1999. They also have to make changes to the rental office or meeting rooms if these rooms are open to the public, okay? And again, this is not a complete list of the rights and responsibilities, but so all public spaces, so all meeting rooms, laundry rooms, private meeting rooms, they need to be accessible. A reasonable accommodation is a change, exception, or adjustment to a property, rule, practice, or service. So that is an accommodation. Reasonable modifications are structural changes. We suggest that all requests for accommodations or modifications be made in writing. I also suggest that if there was any telephone calls, phone conversations, or conversations in person where decisions were made, that be followed up in writing, either with a letter or an email. It's my understanding that I will be permitted to install a shower, to a handrail in my shower. Or it is my understanding that you will install a handrail in my shower. But again, it is best that all this be made in writing just to make sure that everybody understands, everybody has the same understanding of the conversation. Or what isn't permitted. It's my understanding that you will not install a handrail in my shower and that you will not permit me to. That is vitally important, particularly if you're going to be calling an advocate or an attorney. So some examples of reasonable accommodations. And again, I had given some of these earlier. Adjusting the rent date, requesting accessible parking spaces. This is a big one. We used to get a lot of calls about this, haven't in a while, but permitting a live-in personal care attendant to live with a resident with a disability that might need 24-hour assistance, and the waiving of any guest fees or rules due to this need. So some examples of reasonable modifications are a structural change or repair in an apartment that would make it easier for the person with disability to live there. Allowing installation of a ramp at a condo unit when there were only stairs. Modifying doorknobs or levers for someone with mobility impairments. And allowing installation of handrails at a shower. Another example, and we actually did this with my grandma. She lived in Pennsylvania, and after she couldn't live in her home anymore, she moved into an apartment. And she actually owned that apartment, but it was part of a larger apartment complex building. So after she lived in the apartment for a couple years, we needed to make her bathtub a walk-in. Okay, just having the shower chair in it just didn't work for her anymore. So we got with the building owner and received permission to cut out part of her bathtub, the wall, and we hired professionals to do this. Obviously, we again, part of it was cut out so that she could walk in and sit in her shower chair. But then once she moved out of the unit, we had to keep that piece in storage. And then once once she moved out, then the bathtub was put to how it was before, using like bath fitters or a similar agency. And you could never tell that that part of the bathtub was taken out. But again, we had to do it and we had to pay for it, and it had to be put back into its original condition when she vacated the apartment. So who pays for reasonable accommodations? In private housing, like the example I gave with my grandma, a housing provider may require that the tenant resident pay for the cost of modification and request that funds be set aside to restore the unit to its original condition before the modification, of course, except for reasonable wear and tear. The housing provider might also request that a licensed contractor be obtained to make the modification and restoration, if applicable, to make sure it is safe. Insurance reasons, all that. The housing provider, they may pay for the cost of the modification if the provider is willing to do so. And that does happen sometimes. This can occur in situations where the provider wants the modification to stay after the resident vacates. Like if they wanted to have, for my grandma, if they wanted to have certain apartment complexes that had that walk-in bathtub, they may have wanted that. So in government subsidized housing, okay, so this is the exception, and I'm sure it's been ringing in everybody's ears. In government subsidized housing, so Section 504, rural development, housing set up for those with disabilities, it is actually the housing provider that typically pays for the modification, unless there is an undue administrative or financial burden. So again, in government subsidized housing, it is the provider's responsibility, usually, to pay for those types of modifications. The handrails is just the most common one. Okay, so service and assistance animals in housing. So what is a service animal? So under the ADA, a service animal is defined as a dog that has been individually trained to do work or perform tasks for an individual with a disability. The task performed by the dog must be directly related to the needs of that person. People with disabilities, they have the right to train the service animal on their own. They have the right to train the animal themselves and are not required to use a professional service dog training program. Under the ADA, for some tasks, a miniature horse can actually also be a service animal. So my next poll, true or false? You can register or certify your service animal online. So let's say you trained your dog, or a friend or family member trained your dog, not through a professional program. You trained your dog on your own. Can you register or certify your service animal online? The answer to that is false. Those are scams, just people trying to get money. If anybody has any questions or concerns about that, please give us a call. We can give you all kinds of resources on the ADA and service animals. So service animals are trained to perform, this is just a short list. Of course, I think the most common is guiding people who are blind. There are also dogs who alert people who are deaf. They can pull a wheelchair, alert and protect a person who is having a seizure. They can remind someone to take prescribed medications, or let somebody know if they're diabetic and their sugar is dropping. They can calm a person with PTSD during an anxiety attack. And there are lots of other duties that a service animal can perform. I've seen a dog that was trained to help find their child. It was a child diagnosed with autism if they ran away. And this dog actually went and woke up mom one night because in the middle of the night, the child spiked a fever and the dog went and got mom. So these animals can do some very, very great things. So again, these are service animal tasks. So assistance animals, again, different from service animals. Assistance animals means any animal or emotional support animal with or without specific training or certification that is kept and used by a person with a disability to perform or assist in performing one or more major life activities. It can also be to ease or ameliorate the effects of the master's disability. And again, there is no requirement. Oh, this is different. There is no requirement that an assistance animal, often referred to as like an emotional support animal or an assistance animal, be trained by a certified trainer. So no assistance animal needs trained by certified trainers. The emotional and or physical benefits from the animal living in the home are what qualify the animal as an assistance animal. So emotional therapy, comfort, or companion animals are not considered service animals under the ADA. So they don't have emotional therapy and comfort animals. They don't have public access, so to stores, restaurants, but they do have rights under the Fair Housing Act. So what is an emotional support animal? So emotional support animals are animals that provide therapeutic benefit for a person with a mental or psychiatric disability or whose mere presence without any training reduces the effects of an emotional or mental disability. In West Virginia, emotional support animals and assistance animals are treated the same. So here was a poll. So what of the following can be an emotional support animal? A lizard, a dog, a pig, fish. So think about that. Can any of those be emotional support animals? It's a trick question because the answer is all of the above. Any animal can be an assistance animal. Again, I've seen lizards. I've met an emotional support snake. Not for me, but you know, yeah, and the most frequent, of course, that we see are dogs and cats, but any animal can be an emotional support animal. Okay, so some requirements for assistance animals. An individual making a request for reasonable accommodation may be required to provide supporting documents outlining the need for the assistance animal. The tenant or the owner of the animal, they don't necessarily need to disclose their disability. We have template letters for doctors, so feel free to give us a call if you would like some of these resources. A request can be denied if there is credible evidence that the animal would be a direct threat to the health and safety of others. So this determination of direct threat must be based on the individualized assessment that relies, of course, on objective evidence regarding that animal's conduct. So again, it's that animals. You know, somebody can't say we don't let any pit bulls live in our apartment. I have met several pit bulls that are great. I met one service animal and I've met several emotional support animals. But yet I've met, you know, I have a little small yappy dog. And if I rented, I'm sure my landlord would not be happy about my little small yappy dog. But, you know, the animal can be barking at all hours of the day, you know, unless it's that animal's job. Like if they're barking to alert somebody to take their medicine or because they're having a seizure, you know, then that was the animal's job. The animal, again, can't be violent towards others. It would need to generally be house trained. You know, accidents happen, but we need to keep those limited. Can't be a cat that is spraying all over the place or like my little white yappy dog ate a hole in our wall, you know, can't be doing that sort of stuff. But again, if you guys have any questions, feel free to give us a call. Educating people and landlords on emotional support animals and service animals. It's something that we do pretty regularly. Okay, so again, the person with the disability is responsible for controlling the animal. It cannot disturb the property. It cannot disturb the quiet enjoyment of the property owners or their neighbors. The animal should be house trained, and the animal must respond to the owner's handler's commands. So not related to housing, but several years ago, we got a call from a client because their service animal and her were kicked off of a bus. So what we found out was that the dog was actually not a service animal, it was an emotional support animal. And again, emotional support animals do not have public access. When the animal was on the bus, it didn't stay with the client, would frequently go up and talk with other people on the bus. It sat on the bus driver's seat, you know, so not under the person's command. Again, it was an emotional support animal, not a service animal. So the dog had rights under the Fair Housing Act, but not public access rights. Okay, eviction. So West Virginia law requires landlords to provide tenants with proper written notification in advance of any attempt to evict them from the rental property, unless the tenant has failed to pay rent and has otherwise violated the terms of the rental agreement. If a tenant is behind on rent or has violated, again, the terms of the lease, a landlord may go directly to court to file action to evict them without giving prior written notice. So what that means is before you get a court order, you know, to appear at court, the landlord has to notify you in writing that they plan on evicting you. So true or false, landlords can forcibly evict a tenant without going to court. So true or false, landlords can forcibly evict a tenant without going to court. So landlords cannot forcibly evict. You do have to go to court first. Tenants have the right to challenge any evictions, and failure by a tenant to answer an eviction lawsuit to appear in court could result in a judgment for possession, which would require that tenants to leave the property immediately. So again, that failure to attend could result in order to immediately vacate. So tenants have the right to present evidence, proof of rent payment, service animal or emotional support animal physician's orders, written repair requests to the landlord in court. Tenants also have the right to bring witnesses to the hearing. You also have the right to request for basically meetings or mediation before. We like to try to prevent going to court as much as possible, and perhaps, you know, agreements can be made. So some of the witnesses that you can bring with you to either to court or to like a pre-hearing meeting with your landlord or you know, building property manager. You can bring neighbors, you know, to support your behavior. You can bring your mental health provider or other service providers. You can bring advocates, etc. So due to COVID, the CDC, there is a current CDC order that protects individuals that are being evicted for non-payment of rent if all of the following are true. And again, this is just due to the COVID pandemic. And again, there's a CDC order that protects an individual that is being evicted for non-payment of rent if all of these have to be true. The individual will earn less than $99,000 in 2020 or $198,000 if they're filing joint. That you have to have sought government assistance to make rental payments. You're unable to pay rent because of loss of income or substantial medical bills. The individual will make payments or partial payments that they can afford. Okay, so if your rent is $500 a month, but you can only afford to pay 50 or 100, you make payments, the minimal, you make payments as to what you can afford. And that the individual will become homeless or forced to move into a shared living situation, so with family or friends, because there are no other housing options available. So that CDC order was just expanded, I believe through April of 2021. So. Okay. So some potential remedies and self-advocacy. Again, request an informal meeting with a landlord to discuss issues or concerns. If you start getting written write-ups, after your first or second one, request a meeting, maybe get an advocate or a service provider to attend that meeting with you. And again, all decisions can be appealed. If you believe you are discriminated against, you do have the right to file a complaint with HUD, the state or local fair housing agency. And I have some contact information for those later on. So several years ago, we received a call about an eviction hearing. And it was one of those where we got the call that morning and the eviction hearing was at 1 o'clock that afternoon. So it was assigned, I picked up and left and went to this, what I thought was going to be an eviction hearing. I arrived and luckily it was not a formal hearing, but it was actually an informal meeting with the landlord, which again, this is great. So the client's home was very cluttered. Now there were no bug infestations or anything like that, but there was a lot of clutter. And myself and then the client's mental health provider was at this meeting. And so we negotiated with the landlord and advocated that she get assistance to have somebody come in and help her declutter. Okay, we made a written agreement for this. And this was done through the local homelessness organization. And so again, we made a rental, we did an informal agreement saying that by such and such date, she would have basically decluttered her apartment. And then I believe we also agreed to more frequent inspections, because I think they usually did monthly inspections, and we moved those to, I believe it was every other week for a certain period of time. But after the meeting, we put all of that in writing. Because there are time limits on when a complaint can be filed with HUD after an alleged violation, it is very important to submit a complaint as soon as possible. The HUD's Office of Fair Housing and Equal Opportunity, they work to eliminate housing discrimination, they promote economic opportunity, and achieve diverse, inclusive communities. So these complaints can be filed online, by email or mail, and you can contact the Fair Housing Equal Opportunity Office at these phone numbers and websites. In the comments or in the description of this, I will include a PDF of this PowerPoint that will include, the hyperlinks, so you can find that information there. And this is where you mail your form or how to inquire about your claim. So the Fair Housing Hub that covers West Virginia is actually in Philadelphia, Pennsylvania. So again, you can call, fax, email. There is a multifamily housing complaint line that that HUD established for HUD insured and HUD assisted properties. And so that way people can report complaints about property management concerning poor maintenance, dangers to health and safety, mismanagement, and fraud. And so this multifamily housing complaint line can be accessed by calling 1-800-685-8470. And here are some additional resources, some Legal Aid of West Virginia, self-help through the court eviction process. The HUD's Fair Housing and Equal Opportunity, that is their website. And then I also included a guidance from HUD. This is a great guidance. It's multi-page, it's question and answer, and it walks you through service animals and assistance animals for people with disabilities in housing and HUD-funded programs. And this includes if somebody has an emotional support animal, they have housing rights in non-pet housing. So even if a landlord says we are no pet housing, that emotional support animal, it is not a pet or service animal. They're not a pet. It's an emotional support animal or a service animal. So again, they have rights in no pet housing. And you wouldn't have to pay any sort of pet deposit, etc. So if there is a landlord that is requiring a pet deposit for an emotional support animal or a service animal, please let us know, or if they increased rent because of that. Here is the local HUD office in Charleston. And again, I will include in the description of this YouTube page, all of this information will be down there. West Virginia also has a Human Rights Commission. So, and I have filed a complaint with the Human Rights Commission before, and they really helped work through the problem. So the complaint forms can be found online, and then as well as there is a guide, there's an FAQ, frequently asked questions for discrimination complaints. So funding for this publication is provided at taxpayer expense by the U.S. Department of Health and Human Services, Administration for Community Living, the Substance Abuse and Mental Health Services Administration, the U.S. Department of Education, Rehabilitation Services Administration, and the Social Security Administration. This program is presented with financial assistance as a grant from the West Virginia Department of Health and Human Resources. These contents are solely the responsibility of the grantee and do not necessarily represent the official views of the funders. Again, my name is Gina Desmond, and I work with Disability Rights of West Virginia. If you have any questions or concerns about the information that I have provided here, please give us a call, shoot us an email. You can also follow us on Facebook or Twitter. And thank you very much.